Kumari Sushmita Dev.
Thank you, Chairperson. I seek your permission to speak from here.
Yes.
I'm elated that I got an opportunity to be a member of this committee, the report of which was tabled on 28th of April. And I am even happier that I have got an opportunity to speak as this bill gets introduced. I wish the House had more members. The reason I say that is often the impression that goes out of the Parliament is that this Lok Sabha has seen many tumultuous times, and maybe on many occasions we have been in too many adversarial positions. But as a young parliamentarian who's come to the Lok Sabha for the first time, I feel I should put on record that where the debate about stalling of Parliament and slow reforms is dominating public space, Chairperson, this is also the Parliament, which I'm proud to be a part of, has seen constructive bills and reforms come its way. To name a few, the historical bill of the coal auctions was passed by both the houses. The amendment to the MMDR Act was passed by both the houses. We saw the capping of FDI in insurance and defense also go up in this Lok Sabha. Today, I would say that the present bill that we are now going to debate, the Insolvency and Bankruptcy Code 2016, is an important reform, a reform that this nation and this economy has waited for. Often, Chairperson, Madam, when I travel abroad and I interact with members of the business society or journalists overseas, often I'm asked that what is the India story and where is it going? Given the huge mandate that this government has come with, will this country see the reforms come at a pace which I think the international world is expecting from India? So therefore, I go back to why I said that I'm elated to speak in this bill, because this code, the Insolvency and Bankruptcy Code, comes as a very important reform to the nation. It is not like India as a country did not have legislation or statutes in place. It definitely did. It had the SARFAESI Act, it had the SICA, it had the Companies Law, and other insolvency legislations that were applicable to individuals and partnerships. But what emerged over the years is, because the legislation was so scattered and it was found in so many different legislations, the system was evolving in a way, Madam, that this legal system was under a huge burden of pending legislations. Some more than 5,000 companies were undergoing the process of liquidation without reaching to its logical conclusion. Madam, this government has repeatedly spoken, or as a part of their public relation exercise, spent a lot of time and effort talking about startups. But for an economy, for a country that is looking for more startups, I feel for a viable business environment, just like startups are important, I think smooth and efficient methods of exits are equally important. I would like to say that today we are all aghast at what has happened in the Kingfisher case. We know that way back in 2012, Madam, this airline was grounded, but before a secured creditor like a bank even saw a piece of any property or asset, I think it was only as recently as in February 2015. So therefore, this code, in this current atmosphere and the news or the debate that is now revolving the Kingfisher case, becomes even more significant. I have to say that as a member of the committee, we have spent hours and I think almost 12 meetings in discussing and debating on our report which has been submitted. So therefore, I think procedurally or morally, I will not have the right to disagree with whatever has been placed by the committee and has been accepted by the government. Very broadly speaking, I would not like to go through every provision of the code because time is short. But I think the key word in this code is speed. I feel the government has given huge emphasis on timely resolution, on timely liquidation. The reason for it is if liquidation as a process becomes time-bound, becomes predictable, we can expect that the entire trend in our country that lending by banks are generally concentrated amongst few big companies who are asset rich. That trend is likely to change because if my chances of recovering from a business that fails improves, then I become much bold when it comes to lending. Firstly that. Secondly, I would say that this code has tried to initiate or has introduced some totally new systems, new institutions, new genre of professionals, which only time will tell that how it unfolds. I think one of which is what we call the insolvency resolution professionals. It may be individuals like chartered accountants or lawyers, or it even may be an agency which will have to be registered with the appropriate authority. Apart from that, we have the bankruptcy board. Also, we are looking at the National Company Law Tribunal, which will be the appropriate authority before which the IRPs will present their resolution proposal. Over and above, very interestingly, generally when we want information about a company, we go to the company law board. We go to the registrar of companies and apply for information. But this code is actually introducing a new entity or a new system known as the information utilities. These agencies will collect financial information about various businesses and collect it in a way that if I today want some information about the business, the viability of the business, any financial information, I can go and apply to the information utilities. So these are primarily, I think, the new side to this code, which I hope that we will be able to succeed in actually implementing. The reality today is that why has this code given importance to speed, like I said, or expeditious liquidation, is because on an average today in this country, the liquidation procedure, despite the fact that the High Court hears it as quickly as it can, and there is an entire body of official liquidators which look into liquidation, that it takes about 3 to 10 years for a company to be completely liquidated. And as a consequence, the people, the lenders or the creditors of their company, the biggest risk, their biggest exposure is that invariably that the assets of the company, the value of the assets of this company depletes, because of which there is recovery is almost negligible or nothing compared to the kind of credit they have extended to that company. Apart from that, what I think that this code has taken a paradigm shift is that once a company enters into a process of liquidation, which was a huge danger, I think, in the past, is management used to be retained. Management of the company used to be retained with the owners or the promoters or the board of directors. In this case, the moment a company applies for liquidation to the appropriate authority, what happens is that the management goes into the hands of the professional, which I think is a very important step in the right direction, because that's how we manage to keep the assets from straying of the company. I will not spend much more time going through the various provisions because that's already a part of the report. But I spent the last 10 minutes talking about the advantages and the good side to this insolvency code, the bankruptcy code. But madam, what I fear is that will we be able to walk the talk? Today in a country like India, I don't think there is any dearth of any legislation. And this is yet another legislation. It is pretty clear to me that if we pass this legislation and make it the law of the land before or by the 31st of May 2016, I have no doubt that our ranking, India's ranking by the World Bank about ease of business will go up by many points. And yes, I would say as a parliamentary, as a young representative, I would like that to happen. I would like that to happen because actually, as per the business report of the World Bank, 2015, India is ranked at 136 out of 189 jurisdictions for resolving insolvencies. So, with this code coming in before the 31st of May, which I hope it will, that we will improve our ranking. But madam, my biggest fear is that because we have through this code created a new genre of professionals, we have created some new, I would say, judicial or quasi-judicial authorities. The question is that will my government be in a position to put life into this policy, put life into this vision that is, I feel, a vision of this code in terms of human resource and in terms of infrastructure. I think it was in May 2015 that the Supreme Court gave great emphasis, and as per the emphasis, to set up the National Company Law Boards. But till today, as far as I know, the appellate body or the the National Company Law, NCLT and the NCLAT, today I believe there are only 11 benches and probably one circuit bench of NCLT in the first phase, which has not yet been established. Over and above that, I had heard that in the beginning of 2016 or before 2017, the tribunals will become operational. Whether that has been done or not, I'm sure the Honorable Minister will reply, will state in his reply. So I urge this government that where we all have worked hard towards this code in the hope that India as a nation will go towards a more vibrant economy, not just vis-a-vis startups, but smooth and efficient exits, and bankruptcy should not necessarily be a stigma like in the case of Kingfisher. Because today, if you give me ease of exit, then I can again start another business. So I hope that infrastructurally and from the point of view of human resource, this government will put in its best efforts. Few suggestions as a member of the committee, I hope the government has or will take on board. There is a clause about recoveries, and whereas it has been seen that the government of India and the state government can actually recover dues up to 24 months preceding the date or commencement of liquidation. When it comes to workman and employee, that period is just 12 months. So the committee had suggested that that be increased to 24 months, because after all, our workforce is the backbone of our country. Apart from that, another suggestion that the committee had, and I think most of us were unanimous on it, Mehtabji has even spoken in the public domain about it, is if we could cover the aspect of cross-border insolvencies, and we had inserted a new section, I think it's 233A, that where the government of India, once this code comes into effect, can actually enter into an agreement with any other nation or country for the implementation of code. Today, again in the Kingfisher case, we have seen that we are going to face cross-border insolvency issues. Lastly, which I feel that I may not have been able to grasp as a member of the committee, But it seems that the government's vision about information utilities, madam, is that anybody can apply to the relevant authority, register itself as an information utility, keep all the information, and then anybody can go and apply for information. But what I'd like to understand from the government is that why can't we have one agency under the government of India, or at least under the supervision or aegis of the government of India, like we have the registrar of companies, rather than have multiplicity, and especially in a case of information, which is trying with the aim to make it transparent, madam, so that anybody who is claiming as a creditor from the company has the relevant information. I wonder why we are giving a facility of many people setting up a information utility as opposed to a single entity under the supervision of the government, so that whatever information we get from that agency is authentic, is correct, and serves the purpose it's meant to. So with these observations, I end my speech, and I would again like to say, madam, that often as a young parliamentarian, I am asked that why is Congress stalling the GST? Why is Congress stalling the parliament? It is a public perception problem. So therefore, I had started my speech by saying that I'm elated to be taking part in a debate for a code or a legislation, which I think is an important reform, and my party supports it. And I hope that it will be perceived as a constructive move by the biggest opposition party, which is my party. Thank you.